Good morning, students, and welcome to our 10th lecture on international law. Previously, we treated the state's responsibility under international law, and having treated that, the next question that students are posing is how do states resolve their problems under international law, or when a state breaches their obligation under international law, what procedures are taken in order to resolve the issue. That is why in international law it is important to discuss the peaceful resolution of disputes between states. That is the lecture we are going to have today. So, today's lecture is on a peaceful resolution of disputes between two sovereign states. Okay? In order to understand this topic, we have to deal with the understanding of what is actually a dispute. Okay? The meaning of dispute was clearly defined by the Permanent Court of International Justice as a disagreement over a point of law or fact, a conflict of legal views or of interest between two nations. Mavrovatis Palestinian concessions case in 1924, that was when the Permanent Court of International Justice gave this definition. Okay? A distinction is sometimes made between legal and political disputes, or justiciable and non-justiciable disputes. Okay? If you understand this fact that there are disputes that are justiciable and ones that are non-justiciable, and you understand that there are legal and political disputes, that would give you a good sense of understanding the politics involved in international law when it comes to peaceful resolution of disputes. Okay? Now, the principle of peaceful settlement of disputes was also enshrined in Article 2, Paragraph 4 of the Charter of the United Nations, where it provides that all member states shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. This was enshrined in the UN Charter, Article 2, Paragraph 4. Okay? All member states shall settle their disputes by peaceful means in such a manner that international peace and security and justice are not endangered. We already know why the United Nations was set up. So this article lays another foundation for the purpose why international or why United Nations was set up ab initio. Okay? So all member states shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. Okay? The principle of peaceful settlement of disputes was also made clear during the 1970 Declaration on Principle of International Law concerning friendly relations and cooperation among states. This declaration provides that states shall seek early and just settlement of their international disputes by negotiations, inquiries, mediations, conciliations, arbitrations, judicial settlements, resort to regional agencies or arrangements, or other peaceful means of their choice. This is exactly how it is stated in the 1970 Declaration on Principle of International Law. Okay, now we have seen that both the Permanent Court of International Justice, both the United Nations, and also now the Declaration, 1970 Declaration on Principle of International Law concerning friendly relations and corporations, made a solid definition on how issues between states has to be resolved. Okay, now they mentioned certain procedures that must or shall be followed that I just mentioned: negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangement. We have to deal with them separately so that you will understand what it is all about. Okay? Let's start with negotiations. Negotiations has to be via a diplomatic method, that is the most simplest way, or negotiations. We have to understand what negotiation means in order to understand how diplomatic method seems to be the simplest way to go about it. Negotiations means discussions between interested parties with a view of reconciling divergent positions. The parties are directly engaged during negotiations. Successful negotiations requires a certain degree of mutual goodwill, flexibility, and sensibility. Okay, now we have understood how negotiations works properly. Now there is something that is also needed during negotiation. It is called good offices. Good offices and mediation involves the use of a third party during negotiation. The third party could be either a state or a third state or a group of states or an international organization or an eminent individual to encourage the disputing parties to come to a settlement. Okay? The use of third party during negotiations to settle disputes between states can be traced back to ancient times. Good offices. What do we mean by good offices? Good offices are involved when a third party attempts to persuade the disputing parties to enter into negotiations and resolve their disputes. Good offices ends immediately the negotiation starts. Okay, so the good offices, the third party that is involved is there to lay foundation for negotiation. The moment he has laid that foundations and the foundation kicks off, that third party has to pull out. He has done his job. Good officer does not participate in the negotiation. The use of good offices is not obligatory though, and the offer of good offices is not binding for the disputing parties. Okay? For example, good offices of the US president in 1906 was used to end the Russian war between Russia and Japan. Good offices of the USSR in the Indian-Pakistan disputes over Kashmir in 1965 was used. Also, good offices of France encouraging negotiation to end the Vietnam War in the early 90s was successful. And also good offices of the United Nations Secretary General relating to Afghanistan in 1988 or to settle the Cyprus problem was used. Okay? So we have talked about how good offices are or is used during negotiation or to initiate negotiation between disputing states. Okay? Now we go to the second way dispute could be resolved as set down by the permanent international court and the United Nations and the other one. So now mediation is the second way to resolving disputes between states. Okay? In comparison with good offices, a mediator is more active and actually takes part in negotiations, suggesting terms of settlement to the disputing parties. A mediator has to enjoy the confidence of the disputing parties and must be impartial and neutral. No effective mediation can be provided without the consent from the disputing parties. The use of mediation is not obligatory, and the suggestions made by the mediators are not binding for the disputing parties. For example, a mediation of the Pope in the Argentine versus Chile territorial dispute over the Beagle Channel was used. The Pope acted as mediator. Also, the USSR acted as mediator between India and Pakistan in 1966. Okay? Algeria acted as mediator to end the hostage crisis between the US and Iran. Also, US acted as mediator between Israel and Egypt in 1979 in Camp David. and also the UN Secretary General acted as mediator during the Cyprus crisis. Okay? Any question? Now, the success of the third party involvement in the settlement of international disputes depends wholly on the influence and persuasive power of that third party. Good offices and mediation are not always easy to distinguish in practice. Okay? Now, we have dealt with mediation in international disputes between states. Now we have to talk about the fourth one, inquiry. Many international disputes involves questions of facts. Disputing parties may agree to appoint an impartial ad court body to produce a finding of disputed facts and to prepare the way for a negotiated settlement. The parties are not obliged to use inquiry or to accept the findings of the inquiry, but almost always do accept them. For example, Dogger Bank's incident between Russia and Britain in 1904. Okay, that is inquiry. Now, the fifth one is conciliation. Conciliation involves elements of mediation and inquiry. A third party, a commission set up by the parties, investigates the facts of a dispute and submits a report containing a suggested terms of a settlement. Conciliation is more formal and less flexible than mediation. Most conciliations were performed by commissions composed of several members, but occasionally states may prefer a single conciliator. The use of conciliation, the report and recommendation made are not binding for the disputing parties. However, in practice, there are some treaties providing for obligatory use of conciliation. Okay? Now that we have talked about the last means of dispute settlement, then we have to talk about the United Nations getting involved in settlement of disputes between states. Now, under the Charter of the United Nations, states are obliged, like I said earlier, to settle their international disputes by peaceful means. In fact, Article 33 of the UN Charter sets out the various methods states may pursue to settle their disputes. It requires the disputing parties to seek a solution by all that we have just mentioned above, for example, negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their choice. This is under Article 33 of the UN Charter. Okay? So, when we come to settlements of disputes by the United Nations, the Security Council gets involved because they have the primary responsibility for the maintenance of international peace and security. To determine if a dispute or situation is likely to endanger international peace and security. This you can find under Article 34 of the UN's Charter. In that case, the Security Council can call upon the disputing parties to settle their disputes. The Security Council may also recommend the terms of settlement if the disputing party so requests. This you can also find under Article 38 of the UN Charter. The Security Council has employed a variety of diplomatic techniques to resolve international disputes. It has frequently called upon the parties of a dispute to negotiate. It has provided some offices and has mediated in many international disputes. Okay? Also, the United Nations uses the office of the UN Secretary General while solving disputes between states. The UN Secretary General may also play a role in resolving disputes between states. The UN Secretary General may alert the Security Council to situations which, in his judgment, are likely to threaten international peace and security. The Secretary General has provided good offices in the past and has mediated in many international disputes. The UN General Assembly may also recommend measures to avert a situation which is likely to impair the general welfare or friendly relations amongst nations. The General Assembly may not take action if the Security Council is already seized with the matter. Okay? Now that we have given United Nations as an example of a means to settling international disputes, we could also lower down to Africa, where African Union is empowered by their charter to engage in this kind of settlement. For example, Peace and Security Council of the African Union, 15 members, are in charge in getting involved with this kind of disputes between two states. The Commission, the Department of Peace and Security, the Conflict Management Division supports and coordinates activities relating to conflict prevention and management. The Peace Support Operation Division plan, mount, manage, and support African Union Peace Support Operation. This we are very used to. If you are from Africa, for example, we will notice that African Union also do play parts in solving disputes between member states when the Security Council instructs them to do so. Okay? Now, Arbitration is the sixth way of solving international disputes between states. Arbitrations has been used for a long time by states as a method of international dispute settlement. Arbitrations is carried out by an arbitral tribunal set up ad hoc to resolve a specific dispute. In arbitration, the disputing parties choose the arbitrators, the location and procedures of tribunal, and determines applicable laws. This is done by a special agreement called compromise. Okay? Arbitral awards are binding for the disputed parties. In fact, the International or the Permanent Court of Arbitration has been set up by the 1899 Hague Convention for the Pacific settlement of international disputes. Recent practices of the Permanent Court of Arbitration has been limited, though. There were only 43 arbitrations between the Second World War till 1990. Okay? Now, the big boss of international dispute settlement is the International Court of Justice. The International Court of Justice is the principal judicial organ of the United Nations. It sits here in Den Haag at the Peace Palace. It began work in 1946, somewhere thereabout, when it replaced the Permanent Court of International Justice, which had functioned in the Peace Palace since 1922. It operates under a statute largely similar to that of its predecessor, which is an integral part of the UN Charter. Okay? How does International Court of Justice get involved? One, we understand that the International Court of Justice is the principal judicial organ of the United Nations since 1946. And we understand that it sits at the Peace Palace here in the Netherlands in Den Haag. The court has a dual role. One is to settle in accordance with international law the legal disputes submitted to it by states, and secondly, to give advisory opinion on legal questions referred to it by duly authorized international organ and agencies. Okay? What is the composition of the International Court of Justice? 1. International Court of Justice composed of 15 judges elected to 9 years term of office by the United Nations General Assembly and Security Council, sitting independently of each other. Not more than one judge of any nationality. Elections are held every 3 years for 1/3 of the seats, and the retiring judges may be re-elected. The judges must possess the qualification required in their respective country for appointment to the highest judicial offices or by jurists of recognized competence in international law. The composition of the court has also to reflect the main forms of civilization and the principal legal system of the world. Okay? What are the jurisdictions of the International Court of Justice? International Court of Justice has jurisdiction to contentious cases between states. Only states may apply to and appear before this court. The court is competent to entertain a dispute only if the states concerned have accepted its jurisdiction in one or more of the following ways: by the conclusion between them of a special agreement to submit the dispute to the court, by virtue of a jurisdictional clause, that is, typically when they are parties to a treaty containing a provision whereby over 300 treaties of conventions contain a clause to such effect, through the reciprocal effect of declaration made by them under the statute whereby each has accepted the jurisdiction of the court as compulsory in the event of a dispute with another state having made a similar declaration. In cases of doubt as to whether the court has jurisdiction, it is the court itself which decides that. Okay? So, this brings us to the end of the international dispute settlement between two sovereign states. As we can see, the International Court of Justice is the last arbiter when negotiation fails, reconciliation fails, inquiry fails. If every other thing fails, then the last resort is here at the Hague International Court of Justice. That brings us to the end of this lecture, and as always, my name is Gabriel. I'm your online lawyer, and my duty here is to give you that A and B in your international law course or any other law course you are pursuing at your various unis. And this brings us to the end of 2024 as we are all going back home to celebrate Christmas and the New Year. We meet again in 2025. I wish you guys a very Merry Christmas and a Happy New Year in advance. Bye-bye.